Hi, and welcome to this latest immigration law update video. Today, I'm going to talk about Group 1 and Group 2 refugees under the Nationality and Borders Act 2022. We're going to look at the rights the different groups have and how to try and rebut a decision that your client be entitled to Group 2 status. So we start in the immigration rules at paragraph 339QA. And this is the provision for a grant of permission to stay on a protection route. And you'll see that Group 2 and Group 1 refugees may be granted different periods of permission to stay and subject to different conditions. So you look at the Roman numerals. Group 1 refugees will be granted what's called refugee permission to stay for a minimum period of 5 years. Whereas Group 2 refugees, Roman 2, will be granted something called temporary refugee permission to stay for a minimum period of 30 months unless exceptional circumstances apply. The Home Office policy document called Permission to Stay on a Protection Route for Asylum Claims lodged on or after 28th June 2022. And that's what we're talking about, claims made on or after the 28th of June 2022, to which the new system brought in by the Nationality and Borders Act applies. The guidance says this: Group 1 refugees will be granted refugee permission to stay in the UK. They'll normally be granted an initial period of 5 years permission to stay, immediate and unrestricted access to the labour market, recourse to public funds, full access to the family reunion route for their family members, the opportunity to apply for a refugee integration loan, a 5-year route to settlement for those who continue to need protection on the settlement protection route, no requirement to demonstrate a knowledge of language and life in the UK when applying for settlement. Whereas look at what it says for Group 2 refugees. They only get an initial period of 30 months permission to stay. They do get immediate and unrestricted access to the labour market. But look, there's a limited access to family reunion for their family members where there are insurmountable obstacles to continuing family life without family reunification. And do note the immigration rules have now been amended and there are two new appendices that deal with family reunion. Recourse to public funds, the opportunity to apply for a refugee integration loan, the ability to apply for settlement after 10 years under the long residency rules. So you'll need that knowledge of life and language. The conditions attached to a temporary refugee permission to stay may change at a later point. The guidance also says that a judge may allow an appeal and then the Home Office will have to decide this. So initially the Home Office might grant a refugee claim and they'll have to decide whether your client is Group 1 or Group 2, or they could refuse it. An appeal is allowed and then the Home Office will have to decide whether your client is Group 1 or Group 2. A judge will not decide it. It will be the Home Office who will decide it, as their guidance clearly says. If they decide your client is a Group 2 refugee, there is what's called the rebuttal process. And this is set out in their credibility in assessing refugee status guidance, which we'll have a look at in a minute. But please note, after the rebuttal process, there is a final decision against which there is no right of appeal or administrative review. So then I suppose you'd be stuck with challenging a decision that you're a Group 2 refugee by way of judicial review. So let's have a look at Section 12 of the Nationality and Borders Act 2022. A refugee is a Group 1 refugee if they've complied with both the requirements set out in subsection 2 and, where applicable, the additional requirement in subsection 3. So what are the two requirements in subsection 2? They are that you've come directly from a country or territory where their life or freedom was threatened. And secondly, that you've presented yourself without delay. If you don't satisfy these, it says in 1B, you're a Group 2 refugee. There is this additional requirement in subparagraph 3. That's where a refugee has entered or is present in the United Kingdom unlawfully. The additional requirement is that they can show good cause for their unlawful entry or presence. And this sets out then in section 12 the different rights you can give a group 1 and a group 2, and we've already gone through that when looking at the Home Office policy. Section 37 it sort of interprets section 12. So section 37(1) says a refugee is not to be taken to have come to the United Kingdom directly from a country where their life or freedom was threatened if, in coming from that country, they stopped in another country outside the United Kingdom, unless they can show that they could not reasonably be expected, there's that key phrase, to have sought protection under the Refugee Convention in that country. Secondly, a refugee is not to be taken to have presented themselves without delay to the authorities unless, A, in the case of a person who's become a refugee while they were outside the United Kingdom, they made a claim for asylum as soon as reasonably practicable after their arrival in the United Kingdom. And then B deals with surplus claims, claims that arose inside the United Kingdom. In the case of a person who became a refugee while they were in the United Kingdom, if their presence in the United Kingdom was lawful at that time, they made a claim for asylum before the time when their presence in the United Kingdom became unlawful. So you do it before your leave to remain runs out. Or 2, if their presence in the United Kingdom was unlawful at that time, they made a claim for asylum as soon as reasonably practicable after they became aware of their need for protection under the Refugee Convention. So if you've become an overstayer, you've got to make that claim as soon as you become aware of your need for protection. So let's summarize the key considerations. Have they come directly to the United Kingdom? Have they presented themselves without delay, either those who fled due to a well-founded fear or surplus claims? Is there good cause for their unlawful entry or presence in the United Kingdom? The standard of proof applicable to considering the criteria of section 12 of the 2022 Act, so whether you're a group 1 or group 2, is the balance of probabilities. Now, in every case where the Home Office decide you're group 2, they have to give the opportunity for you to rebut that. And you will be given 10 working days to provide representations to respond and saying why you should be a group 1 refugee, not a group 2 refugee. But as I said already, once you've done that, there is no right of appeal against the final decision or no administrative review. So this is the guidance, and the link to the guidance that I'm going to go through is at the bottom of this slide. And I'll put that in the description to the video. So this is the Home Office guidance, which says any individual who you deem to be a group 2 refugee must, it's mandatory, be provided with an opportunity to rebut this provisional grouping. You must provide the claimant with a minimum of 10 working days to provide an explanation for why they are not a group 2 refugee. That period of time can be extended following a request from the claimant, as long as that extension is proportionate to the particular circumstances. And in their provisional decision, it says they've got to set out on which grounds you think, or the Home Office thinks, that somebody is a group 2 refugee, whether it's 12(2)A, so that's come directly, 12(2)B, present yourself without delay, or 3, the good cause for being unlawfully in the United Kingdom. On receipt of the response, they'll make a final decision. Obviously, if you don't respond, they're not likely to change their decision that you're a group 2 refugee. So the Home Office policy goes through the different requirements. So this one's about coming directly. So this is the guidance at pages 68 to 71 and gives the factors that the Home Office will consider in terms of the coming directly point. And it says this: you must consider the route the claimant has taken to reach the United Kingdom, specifically any countries in which the claimant stopped, and whether it could have been it could have reasonably expected that they would have been able to make a claim for asylum in a given third country outside the UK. As part of this consideration, you should consider factors including, but not limited to, the time a claimant has spent in a third country, and where I put ... there's more in the guidance, so have a look at it. The access to an effective asylum system, whether the system was accessible and there were safeguards to protect wrongful refoulement, if it was practical for an asylum claim to be made. Also, any mitigating factors must be considered. And also personal circumstances, if there's particular age or vulnerability issues, and how that would impact whether somebody was able to come directly to the United Kingdom. And for each of these sections, the Home Office have provided examples in their guidance. So on page 70, there's examples about coming directly. So scenario 3 says this: a claimant has been locked in the back of a lorry for 2 weeks traveling through Europe and one is unable to get out apart from a short toilet breaks. Consequently, it's unlikely for them to have been reasonably to be expected to seek protection in a given country they pass through. As a result, they would be considered to have come to the United Kingdom directly for the purposes of 12(2)(a). Scenario 4 is interesting because that's about somebody who traveled across Europe and had significant periods of freedom where they were able to go out alone in a city, a populated city. And in those periods, they weren't under the control of a smuggler or somebody else. Even there, the Home Office said you've got to consider the claimant's psychological state and whether they felt they could safely avail themselves of protection of that third country. But normally in that example, you wouldn't have been considered of coming to the United Kingdom directly. What about presenting yourself without delay? That's dealt with on pages 71 to 76 of the guidance. Some of the considerations that have to be considered is symptoms of trauma, language problems, erroneous advice by people smugglers or lack of accurate information, or erroneous advice from people offering immigration advice, relatives or friends in the community, feelings of insecurity, mistrust or fear, previous experiences with the authorities, particularly in relation to gender and sexual identity, fear of detention, fear of border crossings or points of entry. So these are all things you want to address in your representations if you've been treated as a group 2 refugee on the basis you didn't present yourself without delay. And notice this bit at the bottom, which I think is really helpful and worth citing in your representations. Refugees whose flight to safety is often long and arduous and traumatic may need to recuperate both physically and mentally after their arrival. In this period, finding reliable information and taking steps to make an asylum claim is more difficult, and generally will not be reasonably practical for a refugee to make a claim until they have met their immediate needs and have understood the process for claiming asylum in the UK. So that's helpful. The guidance goes on to look at examples where discretion may be appropriate, where there's issues of mental capacity, mental illness, physical capacity, age, trafficking, sexual or gender-based violence, LGBT plus claimants. And again, there are examples given at page 74. So it's worth looking at that and making your representations using this guidance and the scenarios if you've been allocated as group 2 on the basis you didn't present yourself without delay. And certainly I've seen an example of a decision from the Home Office where that's what they've alleged based on what somebody said in their witness statement and their screening and substantive interview. So very important when preparing an asylum claim to take instructions on this before you even get the group 2 allocation letter, because these are the sort of things the Home Office are going to be looking for, and it's worth addressing in your initial witness statement that's submitted with the claim. What about showing good cause for your unlawful entry or presence? That's pages 76 to 78. The guidance says this: this test for an individual having to show good cause for their unlawful entry or presence is likely to be relevant as the determinative factor in deciding whether an individual should be a group 2 rather than a group 1 refugee only in certain limited circumstances. So that's worth noting from the start. And look, have the Home Office actually placed too much reliance on this aspect? Generally, if a refugee has come directly to the UK and presented themselves without delay, those facts alone will, in most circumstances, demonstrate that there were good cause for their unlawful entry or presence. One example of where good cause may be relevant in determining an individual's group status may be where an individual claims asylum while they're illegally present in the UK, having overstayed a visa. Another example may be a refugee who could, without additional risk themselves, have availed themselves of a safe and legal route. Well, there's got to be those safe and legal routes available, but without good cause chose to enter the UK illegally. So in those sort of circumstances, they may rely on this section. An individual should generally, but not in all cases, be found to have good cause for their illegal entry or presence, where there is a causal connection between their illegal entry or presence and their need for protection. An example of this might be where an individual has delayed their claim due to a fear or reluctance of presenting to the authorities, which could be on grounds of negative experiences and or persecution with country of origin state authorities, which are also set out in the attended claim. So, for example, where you've delayed your claim because you're fearful of disclosing your sexuality, for example, that might be a good cause for your unlawful presence in the United Kingdom. And examples are given at the Home Office guidance at page 77. There is legal aid available for this. I wanted to say that, and that's important to note. So there is legal aid to do this rebuttal, but these rebuttal notices are really important. You've got the 10 working days. Use this guidance because there are these significant differences in the rights given to group 1 or group 2 refugees. And remember, once a final decision is made, there is no right of appeal against that. I hope that's helpful. I'll put links to everything I've referred to below this video. Thanks for joining me.